Hello. So today we're going to be looking at the introduction and what are the various categories of law. Because as we've started to look at from the previous lesson about the historical roots of law, from the Magna Carta, Justinian's Code, Napoleon, even Hammurabi, now that there is a law is a lot more of a bigger topic than you might already thought of. So we're going to start to look at the categories of it, whether it's constitutional, international, criminal, family, civil, etc. So let's get started. To start, you might ask yourself, why do we study law? It's actually really good that you have selected to take this course as you have, because by taking this course, you're going to be more knowledgeable of the entire legal system and the independence of the judiciary branch than about like 98% of the average people that are on the streets. But the reason why we study law is to become aware of the law and the legal environment and how it can impact the decision making. Think back to the various origins of how law has evolved from the previous lesson. But also, the reason why we study law is to help you become a more resourceful and knowledgeable consumer. It also presumes that everyone is presuming that you know it, and so you have the beneficial knowledge of having the basic concepts when it becomes applicable. As well, law is a reflection of community values. Do you agree with this action or do you disagree with this action? As an example, a lot of things have been happening lately because of COVID-19. Various civil law matters or family law or even bylaws for that matter have been changing because of the COVID-19 pandemic. And law not only shapes the business environment, but also is shaped by business. So law will evolve and change depending on the values, because essentially, um, a society of rule of law, the acceptance of rule of law, and the independence of the judiciary is there to represent and to protect the values of the community, which also means it can evolve and change as community itself will evolve and change throughout time. So now we mentioned what is law. Essentially, there is not one definite satisfactory term for law. However, law is a system of control, essentially a set of rules which society will operate. And essentially, the citizens must obey these sets of rules or there is a penalty, i.e., Hammurabi. Look for it there. Law is set by the state. Laws is also a system of rules there. Law declares how we must behave and consists of those rules which are enforced by community values through a legal system, as essentially is the courts, the jury, the judges, the codes, the trials, of the whole legal system with that. And by law is also more complex in reality as the quote unquote rules are affected by social, economic, political, and even international procedures there. And that's part of the legal system, which is made up of legal institutions, procedures, and rules there. And also, the law is a system of rules that enable society to function efficiently and harmoniously, like the case of Robert Latimer there. If you actually search up the legal definition in various dictionaries or textbooks, not all rules are laws. There is actually a distinguished difference between law and administrative guidelines, voluntary codes of conduct, voluntary standards, employment acts, human rights perspectives. You get the idea. There's many shades of gray. Many shades of gray. But law, and why we say it, is law, order, morality, and justice. And the preservation of order within the community, essentially are roads rules, rules of the road, etc. There they are reflection of society's values and how society's values will change. They will compete. They want to create victimless kind of crimes. What is fair treatment? How we establish the rule of law. Essentially, there is differences between law and justice and morality in the legal system. An example, in the criminal law, the essence of a crime is that it is a wrong against the community, even though the criminal action may cause only harm to a person. However, the offense may be wrong against the morality of the community, or it may threaten the peace and order of the community, or it may affect conflict within established policy of a governing body in the community, i.e., you're getting the idea, right? There's a lot of variations to it. And sometimes, actually, some crimes, however, do not have a victim in them. Say these quote unquote victimless crimes are made by crimes because they essentially offend what the parliament believes to be the values or the morals of the society or the Canadian community there. As an example, prostitution has been long considered to be a crime, and under certain categories, still on parts of a crime, like Australia. But is there a victim or not? Yeah, it's also been considered to be a crime because it is a conduct at the time to be perceived to be a violation of to what the actual community values are. So what all kind of means is kind of like this political cartoon would imply. Why do we need a society of laws? Well, look at this cartoon, and I think you'll get the kind of the underlying message as to why laws are required. So now we mentioned what is the legal system. Essentially, the legal system is the totality of laws that regulate the state. It is a legally organized community. It is the collection of all of the various legal systems there. And there are types of legal systems from common law to civil law. You can have Islamic, Talmudic, indigenous legal system, constitutional, human rights. Yeah, you get the idea. It is just the sum of everything. That is the legal system. And the genesis of the legal system is that there should be basic requirements. And within these basic requirements, there should be a body of laws. There should be a source of law with the power necessary to create and or alter these laws when the community values require it. Also, some institution or process of the authority to administer and enforce. And one way to interpret that is whether it's the courts there or actually the coercive force. And what I mean by coercive force, we're talking police, whether it's provincial police like the Ontario Police, or the national police like the Royal Canadian Mounted Police, or the local municipal police like Vancouver or Port Moody, or even TransLink for the matter, have kind of like municipal kind of police. You need to have the ability to enforce these laws, which then are judged in the court system. And the actual document of the legal system is the Constitution. And the genesis of the Constitution is a Constitution is the basis of the entire legal system. Essentially, a Constitution is a system of laws, customs, conventions, which define the composition and powers of the organs of the state and regulate the relations of the various state organs to one another, i.e., the Constitution outlines the powers and responsibilities of governed, and the governed is creating the whole legal system, that whole do's and don'ts point of view. Now, with sources with a law, essentially there are three sources of how laws come into place today. And this is in conjunction with the historical origins that we looked at earlier on. First source is customary law. And customary law is law that is established by habitual use of a group or the people over a long period of time. Hence, what I was mentioning about the community values, what people are just doing there. Because one thing, law or the legal system is slow. The actual Canadian system is designed to be very slow, very methodical, which has its benefits, but also its fair share criticisms for it. Another source of law is common law, and that is law that is developed by the courts. You might have heard me use the term already, precedent setting. There are various laws or cases that have been done in the Canadian judicial system, judiciary being the courts, that they have set a precedent whether it is the Oaks case or Robert Latimer, Stephen Truscott, Robert Picton, to name a few. These are laws or values that have cases that have set a precedent. And so these cases are then, every other case that's done in the court system, when applicable, will be compared to these precedent setting cases to see what has been done because it reflects the values of the community or values of Canadian society, the legal system. And then the third source of law is legislation. And legislation are the laws made by the body that is recognized by the legal system as having supreme power and authority to make the laws. Usually that is Parliament, whether it's the Parliament or the legislatures, which is the provincial um, governments, the 10 provinces, for the legislation for it. Like, yeah. There's also the 5 characteristics of law, which the characteristics are certainty, flexibility, fairness, accessibility, and the difference between public and private laws. And the next 5 slides will explain what is meant by this. So with the characteristics of law, we begin with certainty. People in both their personal and business lives should be able to form relationships with others, enter into contracts such as regulating marriage or property acquisition, dispose of property, essentially with certainty, reasonably secures in the knowledge of what they are doing and their understanding of all those effects. It gives you that certainty, that sort of like formality, or better off actually that confirmation that this is for real, this is completely legal there, and you have proof in writing there. It provides the certainty whether you are buying a car for a set price or taking ownership of like an apartment for rental purposes, or I don't know, even buying a plane ticket to go um, to a vacation somewhere. It essentially, the law gives you that formality, that certainty, that essentially that paper trail. Another characteristic is flexibility. The law must be able to respond without undue delay to the challenge of change that occur of all levels of society. There essentially be flexible. And what I was mentioning before is the law represents the values or the morals of society. And even though especially the Canadian legal system, does move really, really slowly, it is flexible. It does provide that flexibility that what was viewed as not allowed under the legal system, say back in like the 1980s with same-sex marriages, is now completely legal from the late 1990s. Or in the early 21st century, the idea of euthanasia for those who might be terminally ill or undue kind of amount of suffering, uh, there is that flexibility. Another characteristic of law is fairness, and the effectiveness of law depends on its acceptance by members of society, and that will not be available where law is inadequate, unfair, or unreasonable. One thing how it comes to fairness is not criminally responsible has been a growing realm under law, as well as taking under considerations First People's values, especially with the community healing, or those who are dealing with mental forms of illness, such as the Greyhound bus beheading situation. Another one is accessibility, and that all should have access to knowledge of the law, either directly or and through intermediaries, whether that is judges being open to consultation or lawyers, community support groups, everyone is accessible to forms of law. And really that goes back to the idea of Justinian with the form of justice and how the legal system needs to be modernized, or the Magna Carta, so as you know, is above the rule of law. It is accessible, right? Um, then you have the classification of law, public versus public law. Public law essentially regulates the interaction of the citizens and the state, i.e., criminal, constitution, administrative law. Essentially, there are many ways to classify as law, and not one method of categorization is better than the other there. But public law essentially deals with interests of the public, and private laws deals with relationships of individuals within their own kind of state or province, city, etc. There, whether it's contract or torts or property law. Essentially, private law deals with individual rights and relationships between the private citizens. Now, continue on with this public law. You have administrative law, company law, constitutional, criminal law, industrial law in some cases, tax law like the CRA or revenue, trade laws. Essentially, Parliament makes laws and the executive carries them out. Government administers this through, say, Parliament. Parliament also will delegate its lawmaking powers to other persons or bodies for it. Whereas, private law is like banking or companies, contract, equality, equity, family, property, succession, or torts, or trust. It's kind of like that individual. So, public is for everyone. Kind of tends to also be kind of lots of criminal law in that matter. Private is the person to person, so mainly the civil law, which goes now back to Napoleon's Code of 1804. And then with classification, right? Criminal law generally aims to punish the offender, whereas civil law tends to want to compensate for those who have been harmed for it. And generally, as we discussed, and coming up with the elements of a crime, um, crime is that it is a wrong against the community, even though the criminal action may have caused harm to only one person, whereas the offense may be wrong against the morality of the community. A crime is considered to be an offense against the community. It is therefore logical that proceedings against the offender should be investigated in the name of the community there. Penalty can be a form of like a jail or fine, whereas civil law, a fine can be a monetary penalty collected on behalf of the community. And with civil law, you have contracts, so like employment, start working in like Starbucks or Tim Hortons. There are contracts between the employer and employee, a payment of the service, like your salary, versus tort laws, which covers things like negligence, trespassing, defamation, nuances, harassment for it. But harassment, as an example of how laws can change and evolve, harassment laws lately in the last couple of years can be both a criminal matter and a civil liable as well. And with civil law, you have corporations and trade, administrative, and family law, whereas criminal law is offenses against the persons, offenses against the property. But really, the difference between criminal law and civil law is that criminal law is a crime against society. Civil law is a crime against the individual, the collective versus the individual there. So as we end this, I'd like you to think about what are the types of civil laws, what are the types of criminal law, and how could they